North Carolina gained an extra congressional seat after the 2020 census, which meant that the North Carolina State Legislature had to draw a new district map to rearrange its growing population into 14 districts instead of the previous 13. The new map was challenged in state court for partisan gerrymandering at the hands of the Republican-led state legislature in charge of the redistricting process. Subsequently, in February 2022, the North Carolina Supreme Court found that the new map violated, among other things, the state constitution's Free Elections Clause. When the state legislature presented the court with the second map, the same court found that the second map was also gerrymandered, and therefore the court ordered that a special master create a third, non-gerrymandered map. So the North Carolina legislature asked the United States Supreme Court to review the state Supreme Court's decision based on the argument that the United States Constitution's Elections Clause gives sole power to state legislatures to regulate federal elections, despite what any of the state's constitution or the state's laws or the state's courts might say. This highly controversial idea is known as the Independent State Legislature Theory. Legal experts claim that if the court holds that this theory is in fact constitutional law, state legislatures will have the power to send any slate of presidential electors they wish to the Electoral College, no matter whom the voters actually choose in a presidential election. The constitutional question before the court in this case was whether the U.S. Constitution provides the state legislature sole authority to regulate federal elections regardless of what any state's constitution, laws, or courts might say. In a decision that many legal experts and political scientists consider to be one of the most consequential Supreme Court decisions in American history, I give you the June 27, 2023 opinion of the court in Moore v. Harper. Chief Justice Roberts delivered the opinion of the court, in which Justices Sotomayor, Kagan, Kavanaugh, Barrett, and Jackson joined. Justice Kavanaugh filed a concurring opinion. Justice Thomas filed a dissenting opinion in which Justice Gorsuch joined, and which Justice Alito joined as to Part 1. Several groups of plaintiffs challenged North Carolina's congressional districting map as an impermissible partisan gerrymander. The plaintiffs brought claims under North Carolina's Constitution, which provides that all elections shall be free. Relying on that provision, as well as the state constitution's equal protection, free speech, and free assembly clauses, the North Carolina Supreme Court found in favor of the plaintiffs and struck down the legislature's map. The court concluded that North Carolina's legislature deliberately drew the state's congressional map to favor Republican candidates. In drawing the state's congressional map, North Carolina's legislature exercised authority under the Elections Clause of the federal Constitution, which expressly requires the legislature of each state to prescribe the times, places, and manner of federal elections. We decide today whether that clause vests state legislatures with authority to set rules governing federal elections free from restrictions imposed under state law. Part 1. The Elections Clause provides the times, places, and manner of holding elections for senators and representatives shall be prescribed in each state by the legislature thereof, but the Congress may at any time by law make or alter such regulations, except as to the places of choosing senators. The clause imposes on state legislatures the duty to prescribe rules governing federal elections. It also guards against the possibility that a state would refuse to provide for the election of representatives by authorizing Congress to prescribe its own rules. Section A. The 2020 decennial census showed that North Carolina's population had increased by nearly 1 million people, entitling the state to an additional seat in its federal congressional delegation. Following those results, North Carolina's General Assembly set out to redraw the state's congressional districts. The General Assembly also drafted new maps for the state's legislative districts, including the State House and the State Senate. In November 2021, the Assembly enacted 3 new maps, each passed along party lines. Shortly after the new maps became law, several groups of plaintiffs, including the North Carolina League of Conservation Voters, Common Cause, and individual voters, sued in state court. The plaintiffs asserted that each map constituted an impermissible partisan gerrymander in violation of the North Carolina Constitution. At trial before a 3-judge panel of the Wake County Superior Court, the plaintiffs presented expert testimony and other evidence to support their claims that North Carolina's General Assembly drew state legislative and federal congressional maps to favor Republican candidates. The trial court agreed, finding that the General Assembly's 2021 congressional districting map was a partisan outlier intentionally and carefully designed to maximize Republican advantage in North Carolina's congressional delegation. But the court denied relief, reasoning that the partisan gerrymandering claims amounted to political questions that are non-justiciable under the North Carolina Constitution. The North Carolina Supreme Court reversed, holding that the legislative defendants violated state law beyond a reasonable doubt by enacting maps that constituted partisan gerrymanders. It also rejected the trial court's conclusion that partisan gerrymandering claims present a non-justiciable political question. The court acknowledged our decision in Rucho v. Common Cause, which held that partisan gerrymandering claims present political questions beyond the reach of the federal courts. But simply because the Supreme Court has concluded partisan gerrymandering claims are non-justiciable in federal courts, the court explained, it does not follow that they are non-justiciable in North Carolina courts. The state Supreme Court also rejected the argument that the Elections Clause in the federal Constitution vests exclusive and independent authority in state legislatures to draw congressional maps. After holding that the 2021 districting maps substantially infringe upon plaintiffs' fundamental right to equal voting power, the court struck down the maps and remanded the case to the trial court to oversee the redrawing of the maps by the General Assembly, or if necessary, by the court. The court entered judgment on February 15, 2022. 2 days later, the General Assembly adopted a remedial congressional redistricting plan. But the trial court rejected that plan and adopted in its place interim maps developed by several special masters for use in the 2022 North Carolina congressional elections. On February 25, 2022, the legislative defendants filed an emergency application in this court, citing the Elections Clause and requesting a stay of the North Carolina Supreme Court's decision. We declined to issue emergency relief, but later granted certiorari. Section B. Following our grant of certiorari, the North Carolina Supreme Court heard an appeal concerning the trial court's remedial order. In December 2022, the court issued a decision affirming in part, reversing in part, and remanding the case. As relevant, it agreed with the trial court's determination that the General Assembly's remedial congressional plan fell short of the requirements set forth in Harper 1. The legislative defendants sought rehearing, requesting that the North Carolina Supreme Court withdraw its remedial opinion in Harper 2. They also asked the court to overrule its decision in Harper 1, although they conceded that doing so would not negate the force of its order striking down the 2021 plans. The North Carolina Supreme Court granted rehearing in Harper 2, and we ordered the parties to submit supplemental briefing concerning our jurisdiction over this case in light of that decision. Following the parties' submission of supplemental briefs in this court, the North Carolina Supreme Court issued a decision granting the requests made by the legislative defendants. The court withdrew its opinion in Harper 2 concerning the remedial maps and overruled its decision in Harper 1. Relying on our decision in Rucho and on a renewed look at the constitutional provisions at issue, the court repudiated Harper 1's conclusion that partisan gerrymandering claims are justiciable under the North Carolina Constitution. The North Carolina Supreme Court dismissed the plaintiffs' claims with prejudice, but it did not reinstate the 2021 congressional plans that Harper 1 had struck down under the North Carolina Constitution. Instead, the court provided the General Assembly with the, quote, opportunity to enact a new set of legislative and congressional redistricting plans guided by federal law, the objective constraints in Article 2, Sections 3 and 5 of the North Carolina Constitution, and this opinion, unquote. The court did not revisit Harper 1's conclusion that the Federal Elections Clause does not shield state legislatures from review by state courts for compliance with state constitutional provisions. We invited the parties to submit additional supplemental briefs addressing the effect of the court's decision on our jurisdiction. Part 2. Before turning to the merits, we must determine as a threshold matter that we have jurisdiction. The Constitution provides for our jurisdiction over cases and controversies. That constitutional requirement ensures that the parties before us retain a personal stake in the litigation. As a corollary to this case or controversy requirement, there must exist a dispute at all stages of review, not merely at the time the complaint is filed. Mootness doctrine addresses whether an intervening circumstance has deprived the plaintiff of a personal stake in the outcome of the lawsuit. The North Carolina Supreme Court's decision to withdraw Harper 2 and overrule Harper 1 does not moot this case. The plaintiffs here sought to enjoin the use of the 2021 plans enacted by the legislative defendants. Harper 1 granted that relief and, in doing so, rejected the Elections Clause defense at issue before us. Prior to both the appeal and rehearing proceedings in Harper 2, the North Carolina Supreme Court had already entered the judgment and issued the mandate in Harper 1. And the time during which the defendants could seek rehearing as to that judgment had long since passed. Recognizing this reality, the legislative defendants did not ask the North Carolina Supreme Court to disturb the judgment in Harper 1 as part of the rehearing proceedings. They instead acknowledged that they would remain bound by Harper 1's decision in joining the use of the 2021 plans. The North Carolina Supreme Court overruled Harper 1, thereby granting the specific relief requested by the legislative defendants. As a result, partisan gerrymandering claims are no longer justiciable under the state's constitution. But although the defendants may now draw new congressional maps, they agree that the North Carolina Supreme Court overruled only the reasoning of Harper 1 and did not disturb its judgment, nor alter the presently operative statutes of North Carolina. In other words, although partisan gerrymandering claims are no longer viable under the North Carolina Constitution, the North Carolina Supreme Court has done nothing to alter the effect of the judgment in Harper 1 enjoining the use of the 2021 maps. As a result, the legislative defendant's path to complete relief runs through this court. Were we to reverse the judgment in Harper 1, a step not taken by the North Carolina Supreme Court, the 2021 plans enacted by the legislative defendants would again take effect. The parties accordingly continue to have a personal stake in the ultimate disposition of the lawsuit. A North Carolina statute with specific application to this proceeding confirms that the controversy before us remains live. Under state law, if the United States Supreme Court reverses the decision in Harper 1, the 2021 maps will again become effective. We have previously found such trigger provisions in North Carolina, no less, sufficient to avoid mootness under Article 3. We also have jurisdiction to review the judgment in Harper 1 under 28 U.S.C. Section 1257A. That statute provides this court's exercise of jurisdiction over final judgments or decrees rendered by the highest court of a state in which a decision could be had. We have, however, recurringly encountered situations in which the highest court of a state has finally determined the federal issue present in a particular case, but in which there are further proceedings in the lower state courts to come. Cox Broadcasting delineated at least 4 categories of such cases in which the court has treated the decision on the federal issue as a final judgment for the purposes of 28 U.S.C. Section 1257, despite additional proceedings anticipated in the lower state courts. As relevant, the second category includes those cases in which the federal issue, finally decided by the highest court in the state, will survive and require decision regardless of the outcome of future state court proceedings. Harper 1 fits within this second category of cases described in Cox Broadcasting. By striking down the 2021 congressional plans enacted by the General Assembly, Harper 1 finally decided the federal issue whether the Elections Clause insulates state legislatures from review by state courts for compliance with state law. That issue both has survived and requires decision because subsequent proceedings have neither altered Harper 1's analysis of the federal issue nor negated the effect of its judgment striking down the 2021 plans. In its decision overruling Harper 1, the North Carolina Supreme Court, in fact, reaffirmed that it retains the authority to review congressional districting plans for compliance with state law. That the North Carolina Supreme Court overruled Harper 1 does not affect the judgment in that case for purposes of Section 1257A. The res judicata consequences of a final, unappealed judgment on the merits are not altered by the fact that the judgment may have been wrong or rested on a legal principle subsequently overruled in another case. The North Carolina Supreme Court has said much the same. That court did not purport to alter or amend in any way the judgment in Harper 1. In short, the record before us shows that Harper 1 finally decided the Elections Clause issue, which has survived subsequent proceedings in the North Carolina Supreme Court, such that it continues to require decision by this court. Justice Thomas sees it differently. He correctly observes that the North Carolina Supreme Court has now dismissed the plaintiff's claims with prejudice. He posits, therefore, that the legislative defendants are not injured by the judgment of Harper 1. but the record before us belies that notion. Harper 1 enjoined the use of the 2021 maps in subsequent elections in North Carolina. Well after the time for seeking rehearing as to that judgment passed, the legislative defendants instead sought rehearing with respect to Harper 2, a distinct decision concerning remedies. The defendants steadfastly maintained in rehearing proceedings before the North Carolina Supreme Court that overruling Harper 1 would not negate the force of its order striking down the 2021 plans. With those concessions on the record, the North Carolina Supreme Court issued its decision overruling Harper 1 and, by contrast, withdrawing its decision in Harper 2. And mirroring their representations before the North Carolina Supreme Court, the legislative defendants now maintain in this court that they continue to remain bound by the judgment in Harper 1. In an effort to cast doubt on these consistent representations by the injured party before us, Justice Thomas contends that the legislative defendants have already received complete relief because nothing now prevents the implementation of the 2021 maps. For the reasons stated above, that would come as a surprise to both the legislative defendants and the North Carolina Supreme Court. The dissent also emphasizes that several of the plaintiffs contest our jurisdiction, but that has been their position from the very beginning, and it did not prevent our granting certiorari. The concessions offered by the legislative defendants as part of the rehearing proceedings, the recent opinion issued by the North Carolina Supreme Court, and the legislative defendants' briefing in this court all tell the same story. Harper 1 continues to enjoin the use of the 2021 maps. Following the dissent's logic and dismissing this case as moot would foreclose the one path to full relief available to the legislative defendants: a decision by this court reversing the judgment in Harper 1. This court has before it a judgment issued by a state's highest court that adjudicates a federal constitutional issue. The defendants did not ask the North Carolina Supreme Court to vacate that judgment. That court did not purport to do so, and the defendants now concede that they remain bound by it. Cox Broadcasting considered our exercise of jurisdiction where the federal issue will survive and require decision regardless of the outcome of future state court proceedings. Unlike cases in which we must anticipate what the future might hold, we now know the resolution of the anticipated state court proceedings. The record shows that Harper 1 finally decided the Elections Clause question. The judgment in that case continues to bind the parties before us, and the 2021 congressional maps would again take effect in North Carolina were we to reverse. Accordingly, we have jurisdiction under both Article 3 and Section 1257A. Part 3. The question on the merits is whether the Elections Clause insulates state legislatures from review by state courts for compliance with state law. Since early in our nation's history, courts have recognized their duty to evaluate the constitutionality of legislative acts. We announced our responsibility to review laws that are alleged to violate the federal Constitution in Marbury v. Madison, proclaiming that it is emphatically the province and duty of the Judicial Department to say what the law is. Marbury confronted and rejected the argument that Congress may exceed constitutional limits on the exercise of its authority. Certainly all those who have framed written constitutions, we reasoned, contemplate them as forming the fundamental and paramount law of the nation, and consequently the theory of every such government must be that an act of the legislature repugnant to the Constitution is void. Marbury proclaimed our authority to invalidate laws that violate the federal Constitution, but it did not fashion this concept out of whole cloth. Before the Constitutional Convention convened in the summer of 1787, a number of state courts had already moved in isolated but important cases to impose restraints on what the legislatures were enacting as law. Although judicial review emerged cautiously, it matured throughout the founding era. These state court decisions provided a model for James Madison, Alexander Hamilton, and others who would later defend the principle of judicial review. In the 1786 case Trevett v. Whedon, for example, lawyer James Varnum challenged a Rhode Island statute on the ground that it failed to provide the right to a jury trial. Although Rhode Island lacked a written constitution, Varnum argued that the state nevertheless had a constitution reflecting the basic historical rights of the English. And, he contended, the courts must honor the principles of the Constitution in preference to any acts of the General Assembly. Varnum won, to the dismay of the state legislature, which replaced 4 of the 5 judges involved. His arguments were published as a pamphlet, which may well have been the most prominent discussion of judicial review at the time of the Philadelphia Constitutional Convention. The North Carolina Supreme Court played its own part in establishing judicial review. In Bayard v. Singleton, the court considered the constitutionality of a 1785 act by the state's General Assembly that prevented British loyalists from challenging property seizures before a jury. The court held the act abrogated and without any effect, for it was clear that the legislature could not pass an act that could by any means repeal or alter the Constitution. Otherwise, the legislature would, at the same instant of time, destroy their own existence as a legislature and dissolve the government thereby established. James Iredell, who would later serve as an inaugural justice of this court, penned at the time an open letter to the public expounding a robust concept of judicial review. The power of the Assembly, he wrote, is limited and defined by the Constitution. The legislature, after all, is a creature of the Constitution. North Carolina and Rhode Island did not stand alone. All told, state courts in at least 7 states invalidated state or local laws under their state constitutions before 1787, which laid the foundation for judicial review. The framers recognized state decisions exercising judicial review at the Constitutional Convention of 1787. On July 17th, James Madison spoke in favor of a federal council of revision that could negate laws passed by the states. He lauded the Rhode Island judges who refused to execute an unconstitutional law, lamenting that the state's legislature then displaced them to substitute others who would be willing instruments of the wicked and arbitrary plans of their masters. A week later, Madison extolled as one of the key virtues of a constitutional system that a law violating a constitution established by the people themselves would be considered by the judges as null and void. Elbridge Gerry, a delegate from Massachusetts, also spoke in favor of judicial review. Known for drawing a contorted legislative district that looked like a salamander, Gerry later became the namesake for the gerrymander. At the convention, he noted that in some states, the judges had actually set aside laws as being against the Constitution. Such judicial review, he noted, was met with general approbation. Writings in defense of the proposed Constitution echoed these comments. In the Federalist Papers, Alexander Hamilton maintained that the courts of justice have the duty to declare all acts contrary to the manifest tenor of the Constitution void. This doctrine of judicial review, he also wrote, was equally applicable to most, if not all, the state governments. State cases, debates at the convention, and writings defending the Constitution all advanced the concept of judicial review, and in the years immediately following ratification, courts grew assured of their power to void laws incompatible with constitutional provisions. The idea that the courts may review legislative action was so long and well established by the time we decided Marbury in 1803 that Chief Justice Marshall referred to judicial review as one of the fundamental principles of our society. Part 4. We are asked to decide whether the Elections Clause carves out an exception to this basic principle. We hold that it does not. The Elections Clause does not insulate state legislatures from the ordinary exercise of state judicial review. Section A. We first considered the interplay between state constitutional provisions and a state legislature's exercise of authority under the Elections Clause in Ohio ex rel. Davis v. Hildebrandt, 1916. There, we examined the application to the Elections Clause of a provision of the Ohio Constitution permitting the state's voters to approve or disapprove by popular vote any law enacted by the General Assembly. In 1915, the Ohio General Assembly drew new congressional districts, which the state's voters then rejected through such a popular referendum. Asked to disregard the referendum, the Ohio Supreme Court refused, explaining that the Elections Clause, while conferring the power therein defined upon the various state legislatures, did not preclude subjecting legislative acts under the clause to a popular vote. We unanimously affirmed, rejecting as plainly without substance the contention that to include the referendum within state legislative power for the purpose of apportionment is repugnant to Section 4 of Article 1, the Elections Clause. Smiley v. Home, decided 16 years after Hildebrandt, considered the effect of a governor's veto of a state redistricting plan. Following the 15th centennial census in 1930, Minnesota lost one seat in its federal congressional delegation. The state's legislature divided Minnesota's then 9 congressional districts in 1931 and sent its act to the governor for his approval. The governor vetoed the plan pursuant to his authority under the state's constitution, but the Minnesota Secretary of State nevertheless began to implement the legislature's map for upcoming elections. A citizen sued, contending that the legislature's map was a nullity in that after the governor's veto, it was not repassed by the legislature as required by law. The Minnesota Supreme Court disagreed. In its view, the authority so given by the Elections Clause is unrestricted, unlimited, and absolute. The Elections Clause, it held, conferred upon the legislature the exclusive right to redistrict such that its actions were beyond the reach of the judiciary. We unanimously reversed. A state legislature's exercise of authority under the Elections Clause, we held, must be in accordance with the method which the state has prescribed for legislative enactments. Nowhere in the federal Constitution could we find a provision of an attempt to endow the legislature of the state with power to enact laws in any manner other than that in which the Constitution of the state has provided that laws shall be enacted. Smiley relied on founding-era provisions, constitutional structure, and historical practice, each of which we found persuasive. 2 states at the time of the founding provided a veto power, restrictions that were well known. Subjecting state legislatures to such a limitation was no more incongruous with the grant of legislative authority to regulate congressional elections than the fact that the Congress, in making its regulations under the same provision, would be subject to the veto power of the President. And long and continuous interpretation, as evidenced by the established practice in the states, provided further support. We noted that many state constitutions had adopted provisions allowing for executive vetoes, and that the uniform practice has been to provide for congressional districts by the enactment of statutes with the participation of the governor wherever the state constitution provided for such participation. This court recently reinforced the teachings of Hildebrandt and Smiley in a case concerning the constitutionality of an Arizona ballot initiative. Voters amended Arizona's constitution to remove redistricting authority from the Arizona legislature and vest that authority in an independent commission. The Arizona legislature challenged a congressional map adopted by the commission, arguing that the Elections Clause precludes resort to an independent commission to accomplish redistricting. A divided court rejected that argument. The majority reasoned that dictionaries of the founding era capaciously defined the word legislature and concluded that the people of Arizona retained the authority to create an alternative legislative process by vesting the lawmaking power of redistricting in an independent commission. The court ruled, in short, that although the Elections Clause expressly refers to the legislature, it does not preclude a state from vesting congressional redistricting authority in a body other than the elected group of officials who ordinarily exercise lawmaking power. States, the court explained, retain autonomy to establish their own governmental processes. The significant point for present purposes is that the court in Arizona State Legislature, the Arizona Redistricting Commission, recognized that whatever authority was responsible for redistricting, that entity remained subject to constraints set forth in the state constitution. The court embraced the core principle espoused in Hildebrandt and Smiley that redistricting is a legislative function to be performed in accordance with the state's prescriptions for lawmaking, which may include the referendum and the governor's veto. The court dismissed the argument that the Elections Clause divests state constitutions of the power to enforce checks against the exercise of legislative power. Nothing in the Elections Clause instructs, nor has this court ever held, that a state legislature may prescribe regulations on the time, place, and manner of holding federal elections in defiance of provisions of the state's constitution. The reasoning we unanimously embraced in Smiley commands our continued respect. A state legislature may not create congressional districts independently of requirements imposed by the state constitution with respect to the enactment of laws. Section B. The legislative defendants and the dissent both contend that because the federal constitution gives state legislatures the power to regulate congressional elections, only that constitution can restrain the exercise of that power. The legislative defendants cite for support Federalist No. 78, which explains that the wielding of legislative power is constrained by the tenure of the commission under which it is exercised. This argument simply ignores the precedent just described. Hildebrandt, Smiley, and Arizona State Legislature each rejected the contention that the Elections Clause vests state legislatures with exclusive and independent authority when setting the rules governing federal elections. The argument advanced by the defendants and the dissent also does not account for the framers' understanding that when legislatures make laws, they are bound by the provisions of the very documents that give them life. Legislatures, the framers recognized, are mere creatures of the state constitutions and cannot be greater than their creators. What are legislatures? Creators of the Constitution. They owe their existence to the Constitution. They derive their powers from the Constitution. It is their commission, and therefore all their acts must be conformable to it, or else they will be void. Marbury confirmed this understanding, and nothing in the text of the Elections Clause undermines it. When a state legislature carries out its constitutional power to prescribe rules regulating federal elections, the commission under which it exercises authority is twofold. The legislature acts both as a lawmaking body created and bound by its state constitution, and as the entity assigned particular authority by the federal Constitution. Both constitutions restrain the legislature's exercise of power. Turning to our precedents, the defendants quote from our analysis of the Electors Clause in McPherson v. Blacker, 1892. That clause, similar to the Elections Clause, provides that each state shall appoint, in such manner as the legislature thereof may direct, a specified number of electors. McPherson considered a challenge to the Michigan legislature's decision to allocate the state's electoral votes among the individual congressional districts, rather than to the state as a whole. We upheld that decision, explaining that in choosing presidential electors, the clause leaves it to the legislature exclusively to define the method of effecting the object. Our decision in McPherson, however, had nothing to do with any conflict between provisions of the Michigan Constitution and action by the state's legislature, the issue we confront today. McPherson instead considered whether Michigan's legislature itself directly violated the Electors Clause by taking from the state the power to appoint and vesting that power in separate districts. The 14th Amendment, by allowing voters to vote only one elector rather than electors, and a particular federal statute. Nor does the quote highlighted by petitioners tell the whole story. Chief Justice Fuller's opinion for the court explained that the legislative power is the supreme authority except as limited by the Constitution of the state. The legislative defendants and Justice Thomas rely as well on our decision in Lesser v. Garnett, 1922, but it too offers little support. Lesser addressed an argument that the 19th Amendment, providing women the right to vote, was invalid because state constitutional provisions rendered inoperative the alleged ratifications by their legislatures. We rejected that position, holding that when state legislatures ratify amendments to the Constitution, they carry out a federal function derived from the federal Constitution, which transcends any limitations sought to be imposed by the people of a state. But the legislature in Lesser performed a ratifying function rather than engaging in traditional lawmaking. The provisions at issue in today's case, like the provisions examined in Hildebrandt and Smiley, concern a state legislature's exercise of lawmaking power. And as we held in Smiley, when state legislatures act pursuant to their Elections Clause authority, they engage in lawmaking subject to the typical constraints on the exercise of such power. We have already distinguished Lesser on those grounds. In addition, Lesser cited for support our decision in Hawk v. Smith, which sharply separated ratification from legislative action under the Elections Clause. Lawmaking under the Elections Clause, Hawk explained, is entirely different from the requirement of the Constitution as to the expression of assent or dissent to a proposed amendment to the Constitution. Hawke and Smiley delineated the various roles that the Constitution assigns to state legislatures. Legislatures act as consenting bodies when the nation purchases land, as ratifying bodies when they agree to proposed constitutional amendments, and, prior to the passage of the 17th Amendment, as electoral bodies when they choose United States senators. By fulfilling their constitutional duty to craft the rules governing federal elections, state legislatures do not consent, ratify, or elect. They make laws. Elections are complex affairs, demanding rules that dictate everything from the date on which voters will go to the polls to the dimensions and font of individual ballots. Legislatures must provide a complete code for congressional elections, including regulations relating to notices, registration, supervision of voting, protection of voters, prevention of fraud and corrupt practices, counting of votes, duties of inspectors and canvassers, and making and publication of election returns. In contrast, a simple up or down vote suffices to ratify an amendment to the Constitution. Providing consent to the purchase of land or electing senators involves similarly straightforward exercises of authority. But fashioning regulations governing federal elections unquestionably calls for the exercise of lawmaking authority. And the exercise of such authority in the context of the Elections Clause is subject to the ordinary constraints on lawmaking in the state constitution. In sum, our precedents have long rejected the view that legislative action under the Elections Clause is purely federal in character, governed only by restraints found in the federal Constitution. Section C. Addressing our decisions in Smiley and Hildebrandt, both the legislative defendants and Justice Thomas concede that at least some state constitutional provisions can restrain a state legislature's exercise of authority under the Elections Clause. But they read those cases to differentiate between procedural and substantive constraints. Smiley, in their view, stands for the proposition that state constitutions may impose only procedural hoops through which legislatures must jump in crafting rules governing federal elections. This conceitedly formalistic approach views the governor's veto at issue in Smiley as one such procedural restraint. But when it comes to substantive provisions, their argument goes, our precedents have nothing to say. This argument adopts too cramped a view of our decision in Smiley. Chief Justice Hughes's opinion for the court drew no distinction between procedural and substantive restraints on lawmaking. It turned on the view that state constitutional provisions applied to a legislature's exercise of lawmaking authority under the Elections Clause, with no concern about how those provisions might be categorized. The same goes for the court's decision in Arizona State Legislature. The defendants attempt to cabin that case by arguing that the court did not address substantive limits on the regulation of federal elections. But as in Smiley, the court's decision in Arizona State Legislature discussed no difference between procedure and substance. The dissent reads Smiley and Arizona State Legislature in a different light. Justice Thomas thinks those cases say nothing about whether a state can impose substantive limits on the legislature's exercise of power under the Elections Clause. But in Smiley, we addressed whether the conditions which attach to the making of state laws apply to legislatures exercising authority under the Elections Clause. We held that they do. Much that is urged in argument with regard to the meaning of the term legislature, we explained, is beside the point, and we concluded in straightforward terms that legislatures must abide by restrictions imposed by state constitutions when exercising the lawmaking power under the Elections Clause. Arizona State Legislature said much the same, emphasizing that, by its text, nothing in the Elections Clause offers state legislatures carte blanche to act in defiance of provisions of the state's constitution. The defendants and Justice Thomas do not in any event offer a defensible line between procedure and substance in this context. The line between procedural and substantive law is hazy. Many rules are rationally capable of classification as either. Procedure, after all, is often used as a vehicle to achieve substantive ends. When a governor vetoes a bill because of a disagreement with its policy consequences, has the governor exercised a procedural or substantive restraint on lawmaking? Smiley did not endorse such murky inquiries into the nature of constitutional restraints, and we see no neat distinction today. Section D. Were there any doubt, historical practice confirms that state legislatures remain bound by state constitutional restraints when exercising authority under the Elections Clause. We have long looked to settled and established practice to interpret the Constitution, and we have found historical practice particularly pertinent when it comes to the elections and electors clauses. Two state constitutional provisions adopted shortly after the founding offer the strongest evidence. Delaware's 1792 Constitution provided that the state's congressional representatives shall be voted for at the same places where representatives in the state legislature are voted for, and in the same manner. Even though the Elections Clause stated that the places and manner of federal elections shall be prescribed by the state legislatures, the Delaware Constitution expressly enacted rules governing the places and manner of holding elections for federal office. An 1810 amendment to the Maryland Constitution likewise embodied regulations falling within the scope of the elections and electors clauses. Article 14 provided that every qualified citizen shall vote by ballot for electors of the President and Vice President of the United States and for representatives of this state in the Congress of the United States. If the Elections Clause had vested exclusive authority in state legislatures, unchecked by state courts enforcing provisions of state constitutions, these clauses would have been unenforceable from the start. Besides the two specific provisions in Maryland and Delaware, multiple state constitutions at the time of the founding regulated federal elections by requiring that all elections shall be by ballot. These provisions directed the manner of federal elections within the meaning of the Elections Clause, as Madison himself explained at the Constitutional Convention. The legislative defendants discount this evidence. They argue that those by ballot provisions spoke only to the offices that were created by state constitutions, and not to the federal offices to which the Elections Clause applies. We find no textual hook for that strained reading. All meant then what it means now. In addition, the framers did not write the Elections Clause on a blank slate. They instead borrowed from the Articles of Confederation, which provided that delegates shall be annually appointed in such manner as the legislature of each state shall direct. The two provisions are closely parallel, and around the time the Articles were adopted by the Second Continental Congress, multiple states regulated the manner of appointing delegates, suggesting that the framers did not understand that language to insulate state legislative action from state constitutional provisions. The defendants stress an 1820 convention held in Massachusetts to amend the Commonwealth's Constitution, after a Boston delegate proposed a provision regulating the manner of federal elections. Joseph Story, then a justice of this court, nixed the effort. In Story's view, such a provision would run afoul of the Elections Clause by assuming a control over the legislature, which the Constitution of the United States does not justify. But Story's comment elicited little discussion and reflects the views of a jurist who, although a brilliant and accomplished man, was not a member of the founding generation. Part 5. Section A. Although we conclude that the Elections Clause does not exempt state legislatures from the ordinary constraints imposed by state law, state courts do not have free rein. State courts are the appropriate tribunals for the decision of questions arising under their local law, whether statutory or otherwise. At the same time, the Elections Clause expressly vests power to carry out its provisions in the legislature of each state, a deliberate choice that this court must respect. As in other areas where the exercise of federal authority or the vindication of federal rights implicates questions of state law, we have an obligation to ensure that state court interpretations of that law do not evade federal law. State law, for example, is one important source for defining property rights. At the same time, the federal Constitution provides that private property shall not be taken for public use without just compensation. As a result, states may not sidestep the Takings Clause by disavowing traditional property interests. A similar principle applies with respect to the Contracts Clause, which provides that no state shall pass any law impairing the obligation of contracts. In that context, we accord respectful consideration and great weight to the views of the state's highest court. Still, in order that the constitutional mandate may not become a dead letter, we are bound to decide for ourselves whether a contract was made. Cases raising the question whether adequate and independent grounds exist to support a state court judgment involve a similar inquiry. We have in those cases considered whether a state court opinion below adopted novel reasoning to stifle the vindication in state courts of federal constitutional rights. Running through each of these examples is the concern that state courts might read state law in such a manner as to circumvent federal constitutional provisions. Therefore, although mindful of the general rule of accepting state court interpretations of state law, we have tempered such deference when required by our duty to safeguard limits imposed by the federal Constitution. Members of this court last discussed the outer bounds of state court review in the present context in Bush v. Gore, 2000. Our decision in that case turned on an application of the Equal Protection Clause of the 14th Amendment. In separate writings, several justices addressed whether Florida's Supreme Court, in construing provisions of Florida statutory law, exceeded the bounds of ordinary judicial review to an extent that its interpretation violated the Electors Clause. Chief Justice Rehnquist joined in a concurring opinion by Justice Thomas and Justice Scalia, acknowledged the usual deference we afford state court interpretations of state law, but noted areas in which the Constitution requires this court to undertake an independent, if still deferential, analysis of state law. He declined to give effect to interpretations of Florida election laws by the Florida Supreme Court that impermissibly distorted them beyond what a fair reading required. Justice Souter, for his part, considered whether a state court interpretation transcends the limits of reasonable statutory interpretation to the point of supplanting the statute enacted by the legislature within the meaning of Article 2. We do not adopt these or any other test by which we can measure state court interpretations of state law in cases implicating the Elections Clause. The questions presented in this area are complex and context-specific. We hold only that state courts may not transgress the ordinary bounds of judicial review such that they arrogate to themselves the power vested in state legislatures to regulate federal elections. Section B. We decline to address whether the North Carolina Supreme Court strayed beyond the limits derived from the Elections Clause. The legislative defendants did not meaningfully present the issue in their petition for certiorari or in their briefing, nor did they press the matter at oral argument. Counsel for the defendants expressly disclaimed the argument that this court should reassess the North Carolina Supreme Court's reading of state law. When pressed whether North Carolina's Supreme Court did not fairly interpret its state constitution, counsel reiterated that such an argument was not our position in this court. Although counsel attempted to expand the scope of the argument in rebuttal, such belated efforts do not overcome prior failures to preserve the issue for review. State courts retain the authority to apply state constitutional restraints when legislatures act under the power conferred upon them by the Elections Clause. But federal courts must not abandon their own duty to exercise judicial review. In interpreting state law in this area, state courts may not so exceed the bounds of ordinary judicial review as to unconstitutionally intrude upon the role specifically reserved to state legislatures by Article I, Section 4 of the Federal Constitution. Because we need not decide whether that occurred in today's case, the judgment of the North Carolina Supreme Court is affirmed. It is so ordered. We've come to the end of the opinion. Until next episode, thanks for listening to What SCOTUS Wrote Us.